Hello and welcome to End of Life University podcast, where we share real talk about life and death. I'm your host, Dr. Karen Wyatt, and this is episode number 295. We're getting awfully close to that 300 episode milestone that I've been looking forward to. And in a few moments, I'm going to share with you a very interesting interview I did with attorney Kathryn Tucker. And some of you, if you're regular listeners, you might recall that back in November, I did an interview with Dr. Ira Byock about the benefits of psychedelic medications like psilocybin for people at the end of life. And this episode today is a companion to that episode in some ways, as we are actually going to take a look at the legal end of what is happening in the movement to try to legalize psilocybin so that it can be used for patients at the end of life. Kathryn is the attorney who's been working on this legal case. So it's been really interesting to talk with her and hear about what's going on behind the scenes. I think those of us who are working in the end of life field may not realize all the work that's going on by law firms and attorneys who are helping us to get laws passed and change things in our society that will help us in the care we're trying to offer to patients. So you'll be hearing that in just a moment. And before we get to that, I want to remind you that the workshop on grief by Ben Kintish from Life Review, the Hospice Musical, is coming up on Sunday, April 25th, 4 p.m. Pacific, 7 p.m. Eastern. There will be a link where you can register for the workshop. There is a fee. We're charging $20, and the funds that are raised will be split evenly between the Denver Hospice and Life Review, the Musical. So Ben is going to be sharing songs and stories about grief that come from the musical, Life Review, the Hospice Musical. So it will be a really fun evening. He's a fantastic entertainer, and so I hope you can join us for that. But again, go to the show notes at eolupodcast.com and look for episode number 295, and you'll find a link there to register. And then another reminder that there's still time this month, even though National Healthcare Decisions Day is already past us now. You can still go to mylivingvoice.com, create an account there, and register your healthcare proxy, and Vital Decisions will plant a tree. And I mentioned this in previous episodes. Their goal is to plant 1,000 trees this month. So it's all free. You can just go there, create an account, and document the fact that you've chosen a healthcare proxy and spoken to that person to make sure they agree to be your proxy, and also that they know what your wishes are for the end of life. So join us in this campaign. Pick a proxy and plant it forward by going to mylivingvoice.com. So now we'll move on with the interview with Kathryn Tucker. And as always, stay tuned after the interview, and I'll come back with a few takeaways and to say goodbye. So here we go. Today, I'm very honored to welcome our guest, Kathryn Tucker. Kathryn is special counsel at Emerge Law Group, where she co-chairs the Psychedelic Practice Group. She is also executive director of the End of Life Liberty Project, ELLP, and she served 2 decades as director of advocacy and legal affairs for Compassion and Choices, working to improve care and expand choice at the end of life. She is recognized as a national leader in spearheading creative and effective efforts to promote improved care for seriously ill and dying patients. She appears frequently on television and radio discussing end-of-life care, decision-making, and physician-assisted dying, and she has authored numerous articles on these subjects that have been published in legal and medical journals. And when I say numerous, that's really an understatement, because Kathryn literally has a 10-page list of articles and presentations she's done. So you can find out more about her work at the website emergelawgroup.com. And Kathryn, I want to welcome you and thank you for taking time out of your busy schedule today.
Thank you so much, Karen. Happy to be with you and your audience.
Well, we're going to be discussing the legal case for the use of psilocybin for palliative care. But before we start on that, as I mentioned, you have been so prolific and such a force in this work that you've been doing on behalf of people at the end of life. And all the rest of us are really benefiting from your work that at least seems to be behind the scenes. You're, as far as I can tell, you're working hard on the legal end of things, which is something I don't often think about. So I wanted to ask you, before we dive into our topic, a little bit about what inspired you in the first place to get into these issues in your law practice.
And that's now so long ago. I've been doing this work now for 30 years, if you can imagine that. I think what it was is I had been in law school with a hope to do work that felt meaningful in some way. I didn't have a clear idea of what that would be. But I wanted my work in law to be to improve some corner of the world in some capacity. I didn't just want to be a corporate commercial lawyer. And I had the opportunity as a very new young lawyer to represent the campaign for the first ballot measure in the country about death with dignity. And that was in Washington State in 1990 and 91. And I was with a big firm at the time that had a very generous practice of allowing its young lawyers to do pro bono work that interested them. And I took on the role of representing the campaign for Washington Citizens for Death with Dignity. And that campaign came close to passing. It did not pass. Out of the ashes of that effort came the organization that was known as Compassion in Dying. And I worked with that Washington State nonprofit as its pro bono counsel for some time. And then things just unfolded to where I left the firm and was full-time in the nonprofit world for many years. And so, and then here we are today. And that Washington effort at the ballot did eventually succeed when Oregon, a couple of years later, really standing on the shoulders of Washington's effort, passed its Death with Dignity Act, which was the first state law in the country permitting aid in dying. And so, that, of course, was very exciting. And then Washington passed its own measure in 2008. So it's been a lot of really interesting work that has felt meaningful. And I feel very fortunate to have been able to do it.
Well, indeed, we're all benefiting from your work. So you have definitely found an area of work that is meaningful and that's contributing a lot to our world. So I just want to express gratitude to you for that.
Oh, thank you. You're so kind.
Today, we're going to talk about your most recent work with psilocybin. And I thought we should maybe set the stage here by talking a little bit about why psilocybin as a palliative care tool and what are the benefits and the promise of psilocybin.
Yes. Well, it's so interesting. And I would never have predicted that I would be in this arena. But it is through the lens of palliative care and the promise that psilocybin holds as an important new tool for the palliative care toolbox that has brought me to this work. So I think that I first started learning about the quite amazing promise of psilocybin to relieve non-physical suffering in patients with serious life-threatening illness when I read Michael Pollan's article in the New Yorker magazine called The Trip Treatment. And that's probably now 8 or 10 years ago that he wrote that. That article then led to his publishing his book recently called How to Change Your Mind. So that article was kind of the seed for the book, which is quite wonderful. And many may have already read it. It's very popular. And And what he was reporting on studies at leading national universities, Johns Hopkins, NYU, UCLA, and others, that when a terminally ill patient who had very serious anxiety and or depression had a single guided therapeutic session with psilocybin, that individual obtained enormous relief. And it was quite remarkable how profound the impact. And they did go back and interview those patients over time. And there are a number of studies that show that that effect was enduring. So a patient who went in with anxiety and depression came out with it largely ameliorated, and that remained the case even months later. And so that, of course, is so exciting if you care about the experience of patients going through terminal illness. And it seemed to me that it filled a gap in the palliative care toolbox. We have made these huge strides in developing modalities and medications and techniques for addressing physical pain and distressing symptoms. And that's really important and to be celebrated. Yet less progress had been made around non-physical suffering. So I think this is why there's so much excitement in the palliative care community about the promise of psilocybin in particular to be added to the palliative care toolbox.
And I think it's definitely exciting that those results came about after a single guided experience with psilocybin. So it's just to make it clear, it's not a medication that people take every day. It can be a single experience that can actually have that much benefit.
Yes. And, if you have read Michael Pollan's work, or if you have read the underlying studies, you immediately begin to understand why that is so. Because what is reported by the patients and the researchers is that, what's happening for the patient is they are experiencing a profound change in the way they think about their life and their death and what they think about what follows death, and that is remarkably transformative.
Yes, it's so powerful, and there's literally nothing like that we can offer to our patients to help bring them to that place.
Well, or I would, maybe someone could say, well, if that person did 20 years of intensive yoga practice and meditation, they might achieve that kind of transformation. And I appreciate that. But for a lot of people with terminal illness, that, of course, is not an option.
Yes. Well, so Kathryn, let's discuss the state of things right now here in the U.S. Is psilocybin accessible for patients right now? And if so, where and how?
No, it's not. I should say it is not legally accessible. Psilocybin is identified by the Drug Enforcement Administration as a Schedule I controlled substance. Substances on that schedule are the most restricted. They cannot be prescribed. They cannot be legally accessed. So I qualified my answer because at the same time, there's quite a large underground market in psilocybin. Psilocybin is naturally produced in a mushroom, the psilocybe mushroom, and that's well known. And those mushrooms grow prolifically and they can be obtained in the underground. The problem, of course, is terminally ill patients and the professionals providing care to them do not want to go into the underground. What they're really hoping for is legal access that can happen in the care of a qualified clinician, where there is no exposure to criminal prosecution. Of course, physicians cannot put their licensure to practice medicine at risk, which is what would happen if they were engaging in criminal conduct. And so there's no legal access in the US unless you're able to enroll in a clinical trial. Clinical trials are going on around the country. You can go to clinicaltrial.gov and type in psilocybin and see where they're enrolling those trials. They're in certain, they're near these large research universities that I mentioned. So not everyone is going to be able to enroll in a clinical trial, and hence our advocacy effort to open access to legal access to psilocybin for seriously ill patients under the right to try laws.
Oh, and could you explain more about that and what the right to try law is?
So these laws have been enacted over the last 6 years in 41 states to date, and also by the federal Congress. The United States Congress has adopted its own federal version. And what they all recognize is that patients with life-threatening illness do not have the luxury of time to wait for the very long, slow process of new drug approval to wend its way through the FDA procedures and protocols. And therefore, if such a patient wants to access what is referred to as an eligible investigational drug, that should be permitted. What constitutes an eligible investigational drug is that the drug must have successfully completed a phase 1 clinical trial, and it must remain under investigation in the FDA drug approval process. Those requirements are met by psilocybin, and it seems, therefore, to fit under the protection afforded by the right to try laws. Therefore, the patient population that is eligible under right to try should be able to access it for therapeutic purposes. And that's what our case, our recently filed case, is all about.
So you have to actually get the legal permission. Is that for each patient in order to have the right to try? Do they have to go through a court process in order to have the right to try it, or
no?
Okay.
No. What I believe is possible here is that this lawsuit will establish the principle that psilocybin is an eligible investigational drug, and that therefore patients with life-threatening illness are entitled to access it for therapeutic purposes. If we can establish that in this case, then that rule should apply for patients elsewhere. And not every patient would need to undertake this kind of lawsuit, which is quite a daunting undertaking.
Yes, it sounds like it. So being able to win this one case could make a difference for everyone around the country who might benefit from psilocybin.
If they are in the eligible population. Mm-hmm. Yes.
I'm very curious about the history of how it became a Schedule 1 drug. That seems really surprising to me in a way that a little bit unjustified in my mind. Do you know anything about that history? I know it happened like in 1970.
Yes. Well, I am a bit of a student of that history because it's absolutely fascinating. And the book I mentioned by Michael Pollan, called How to Change Your Mind, does a very nice job of reviewing all of that history. There's another book that I very much recommend called The Harvard Psychedelic Club, which recounts the early history. And what that history is there had been a tremendous amount of excitement in the research and medical communities about the promise of psilocybin and other drugs, which are considered to be psychedelic substances. And the research and the progress of examining the potential of those drugs really went into the deep freeze in the 1960s for a host of reasons. And research shut down. And so the possibility that these substances would be able to be accessible has just been frozen. It's been on hold until intrepid researchers began to make proposals for more clinical trials. And that modern era of research is what is now been going on for the last 15 years or so, with the findings now widely reported in the medical literature and starting to be noticed by the culture at large, as reflected in the great success of Michael Pollan's book, for example. People are really eager to see the promise of these substances, which, by the way, have application for other really significant mental health conditions. And the one I'll mention, that I've been very moved by is the tremendous value in relief of PTSD, and particularly in veterans, where the finding is that veterans who have so much post-traumatic stress trauma that they really can't function are returned to a functional ability following use of therapeutic psychedelics. So it's a fascinating history. I recommend both of those books. It's much too much for this call. Maybe you'll have one of those authors come on your show and share with your listeners that absolutely fascinating history.
Yeah, very interesting. Well, so let's go back then. So you are working this test case that you're taking to court. And could you tell us a little bit about that case?
Yes. So in Seattle, there is an integrative oncology clinic called the AIMS Institute, which stands for Advanced Integrative Medical Science, AIMS. And its palliative care director is a respected member of the American Academy of Hospice and Palliative Medicine, Dr. Sunil Agarwal. And Dr. Agarwal works really hard to relieve the suffering of his patients with advanced cancer. And he includes in his practice ketamine therapy, which ketamine is a substance that can be accessed. It is on a schedule that allows physicians to access it for therapeutic use. And it's considered something of a cutting edge therapy. But even with that therapy, he still has cancer patients who have not been able to get relief from crippling anxiety and depression. And so he has followed closely these studies. He, in fact, did one of his fellowships at NYU when the studies of psilocybin in patients with cancer were ongoing. So he's deeply familiar with the promise of this medicine, and he very much wants to be able to offer it to his dying cancer patients. And so I represent Dr. Agarwal, two of his patients with advanced cancer, and his clinic, the AIMS Institute, in pursuing access. And so, of course, Dr. Agarwal is not able to step outside the bounds of the law. And the current law is that this substance is not accessible. So we approached the DEA, the United States Drug Enforcement Administration, to ask it how it would accommodate the right to try, which is the law of the land and appears to apply by its terms to the investigational drug psilocybin. And we received the message back from the DEA that access for therapeutic use was denied, that if Dr. Agarwal wanted to access that drug, he should apply to be a researcher. That, of course, is a very different capacity and involves all kinds of burdens that would not allow access in any reasonable period of time, and was a completely unsatisfying answer. And so in light of the position that the DEA took, which seems to be in contravention of the law, both state and federal, because Washington state adopted a right to try statute in 2017, the United States legislature, Congress, adopted a right to try law in 2018. They both clearly appear to apply to psilocybin. And so the question now for the court will be, is that correct? And if so, how will DEA comply with state and federal law? I did have a case that I was involved with where you and some of your listeners may remember that when Attorney General John Ashcroft was in office, he was offended by the fact that Oregon empowered its terminally ill citizens to choose a more peaceful death through aid in dying. And he issued a directive from the U.S. Attorney General office that said any physician who provided aid in dying under the Oregon Death with Dignity Act would be exposed to punishment under the Controlled Substances Act. That case went through the federal courts. I represented a group of Oregon patients in challenging that directive. The state of Oregon came in, as it should, and defended its statute. And at every level of the federal courts, the ruling was that the Attorney General had overstepped the bounds, the scope of his authority. And that's largely because the regulation of the practice of medicine is primarily the responsibility of the states. So when a state has enacted a statute making clear that a particular medical practice is permitted in that state, it is not permissible for the federal Attorney General, the United States Attorney General, or the Drug Enforcement Administration to nullify that validly enacted state law. That case, which is now referred to as Oregon versus Gonzalez, is a precedent of some import to this case, because we do see here the DEA, a federal agency, trying to prevent, obstruct, nullify a state and federal law, and that should not be permissible.
So that, in a sense, set a precedent here that likewise the DEA should not be able to deny the right to try when that's already a law of the state and a federal law.
Yes, exactly. So that's what we will be trying to bring forward to the court, and hopefully the court will see it that same way. And the DEA will need to find an avenue that allows access, which both state and federal law contemplate.
And what do you see as the impact if you win this case?
Well, I would like to think that the DEA would get busy making a user-friendly opportunity for clinicians like Dr. Agarwal to get the kind of approval from the DEA so that they can access this drug. So, to make it a little bit more concrete, we did locate a manufacturer of psilocybin that is already a registered manufacturer and distributor of this drug with the DEA. And we approached that company and introduced Dr. Agarwal and his intention to use this drug therapeutically with terminally ill patients, and asked if that company would supply the drug. That company was willing to do so as soon as it had confirmation of permission from the DEA. So this is the kind of thing that is necessary. A registered manufacturer and distributor must have some evidence that distributing to Dr. Agarwal does not put it at risk. So whether the DEA, issues an exception to psilocybin that would be available to other clinicians, or whether it creates a special registration, we don't know. And in some sense, that's really the responsibility of the agency to understand what right to try provides, and then to create an avenue that allows that to function. So this is something that will have to be worked out.
This feels almost painful to me when I think about the fact that every day that goes by, there are patients who could be benefiting from this therapy, but who cannot legally access it. And I can see why you're passionate about working on this case.
Yes, I too am saddened that there is a patient who could benefit who is being denied access. That is an irreparable kind of harm. And, again, kind of putting this in the frame of reality that we already empower terminally ill patients with the ability to access controlled substances to eradicate consciousness and avoid suffering. That's the intervention known as palliative sedation, where IV medication is administered to bring about total loss of consciousness, total sedation, so the patient isn't aware of physical suffering. And food and fluid are withheld until death arrives. That's legal in all 50 states. It's an important option. I was involved with the cases that established that as a legal option, and it's important that it's available. The option of aid in dying is available to an increasing number. About a fifth of the U.S. population live in states where aid in dying is an available option, where the patient ingest controlled substances to advance the time of death. So given that we allow that kind of access to controlled substances for this population of patients, doesn't it make sense that we would allow them access to a controlled substance shown to elevate and expand consciousness and improve the experience the patient has as they are going through their terminal illness?
Yes, definitely. And are there groups stepping up to support your case and file briefs with the court?
Yes. So the Friend of the Court briefs, also known as amicus briefs, I expect we will see a significant participation. First, the groups that worked so hard to see the right to try laws enacted, they will come forward, because the tremendous amount of energy and attention and effort that went into the quite remarkable passage of 41 laws and a federal law in the space of 6 years. And by the way, some of those laws, including, for example, the law in the state of Washington, were adopted by unanimous vote, meaning every single legislator voted in favor, which is very rare in this day and age. I think we will see those groups participate because these laws should be respected. They should be allowed to bear forth their promise. I believe we will also see the participation of groups that care about end-of-life care. So, for example, a group that I've worked with for 30 years in Washington State, which is now called End of Life Washington, but it is the same group that was called Compassion in Dying way back in the early 1990s. That group adopted a policy in, I believe it was September of last year, very supportive of legalizing psilocybin therapy, making it accessible for a palliative care tool for terminally ill patients. That group speaks with tremendous gravitas to the interests of people with terminal illness. And so I'm really pleased at their adoption of a very careful, well-written policy, which is up on that organization's website. I think it's a model for other end-of-life care groups. They will be participating in this case as an amicus. And then I think we'll see quite a few other groups. The American Civil Liberties Union will likely participate. I'd very much welcome the involvement of the Washington State Attorney General Office. Just like the Attorney General for the state of Oregon stepped up to defend its Death with Dignity Act when that was under threat by the federal government, I'd like to see the Washington Attorney General step up and defend the Washington right to try, which is clearly under threat from the federal DEA.
When will this be going to court?
So we filed last week, and courts move very deliberately and usually quite slowly. We do represent patients with terminal illness, so I am preparing a motion to expedite, asking the court, when it sets its calendar, to move this case to the front of the line, because with patients dealing with terminal illness, if there isn't justice soon, then justice is forever denied.
Yes, absolutely. Well, Kathryn, is there anything that listeners to the show could do in support of your case? Anything, if there are people working in this field or part of organizations that would be helpful to you?
Yeah, I would love to hear from anyone who has that kind of a position where they might bring a voice forward. So, for example, if they are interested in participating as an amicus, I am kind of serving a connector role to introduce different amici to each other where it makes sense for them to join on a single brief. So, for example, on the brief of End of Life Washington, I hope that possibly the Washington State Hospice and Palliative Care Organization will join, because they have very much shared interest. So I'm doing that kind of coordination among amici. So if anyone listening represents a group, and sometimes even very influential individuals can file an amicus brief in coalition with other thought leaders. So don't hesitate to reach out. We are also doing some fundraising to support my investment of time and energy in this case. And we've set up a fund for that that's called the Right to Try Advocacy Fund at a nonprofit called the NOAC Society. And so anyone who wants to support the financial aspect of this case, I'm very happy to give the details of how to make tax-deductible contribution to that nonprofit for this particular fund. And that will, enable me to do a good job and give this matter the attention that it needs to wend its way through the court system.
And I can link to that in the show notes for this episode if anyone wants to go check on that and how to participate in the fundraising. And then, Kathryn, is it all right if we use your email address for people to contact you?
Sure. Yes. Please contact me at Emerge Law Group, and I'm very happy to help people, find what coalition they might fit in on this, if they're interested in taking that kind of amicus role.
And Kathryn, are there any other efforts going on right now to open access to psilocybin therapy?
Well, yeah. So, interestingly, I was involved with the effort in the state of Oregon. Once again, Oregon is taking a pioneering role in being the first state to enact a psilocybin therapy law. And so on the ballot last fall, Oregon voters voted on what was known as Measure 109, and which is now called the Oregon Psilocybin Services Act. And that act passed. And a majority of Oregonians voted for Oregon to be the first state in the country to allow therapeutic access to psilocybin. So a lot is happening right now in Oregon to make ready for the implementation of that law. That law has a 2-year development period on the front end. And so there will not be access to psilocybin under that law before 2023. But what is happening now is the creation of an advisory board within the Oregon Health Authority to consider and establish what kind of training the facilitators should have, what kind of licensing the facilities should have, and so forth. So I think that reflects this growing interest in the promise of this drug to address a variety of mental health challenges. And I think the Oregon law, already we see other states introducing measures similar to it. And so once again, I think Oregon is something of a leader for other states, as has been the case in the past.
Yeah, I was going to ask you that if you foresee other states following suit down the road. And maybe it will take a little time for them to see how it rolls out and what the benefits are in Oregon. But I certainly hope so, because that would be another avenue of getting the therapy to patients a little bit more quickly, hopefully.
Yes. And I should say that if we're successful with our right to try approach, that could open access to psilocybin even in the state of Oregon before 2023 under right to try for that particular population. So that is a potential as well.
And then did you say there are 41 states with right to try laws? So if you are successful, patients in all of those states should have access?
Yes. And also another way to think about it is the federal enactment should govern nationwide. So it's helpful to our case that there is a Washington state enactment, because it makes it all the more clear that the state of Washington has determined that psilocybin therapy for this population is appropriate as a medical practice. But what I would say is, even in the states that haven't adopted right to try statutes, there is a federal statute that provides for this, and that is the law of the land.
Oh, so that's really good to know. So I think each one of us who is interested in end-of-life care, and especially compassionate care for those who are suffering, we all need to get educated about this, because it's still really fairly something new for us to hear about. But we all need to become advocates in our own states and communities as well, and watching out for any ways that we could get involved.
Yes. Absolutely. And I'd be very happy to, if you like to put up on your link following this talk, I've just published an article in an Oregon Law Review that talks at great length about the Oregon Psilocybin Services Act and speaks briefly about the right to try. And so for those who've listened to the show and are really eager to learn more, that article might be very interesting.
Oh, I will definitely do that. I'll definitely link to that. And Kathryn, it's been fascinating to talk with you. And I learned so much today that I didn't realize was happening in this area. And I'm so grateful to you for this work that you're doing.
Well, it's so exciting. And I hope that all of the listeners now know a little bit more and can start to follow it, because we do need to fill that gap in the palliative care toolbox. And so, I can foresee a possible day not too far in the future where it would be considered best practice for clinicians caring for people with terminal illness to explore the possibility of psilocybin therapy, that would just be on the menu of modalities that might bring relief that a clinician could offer to a patient who is struggling with anxiety and depression with regard to their illness. So I hope that day comes and comes soon.
Oh, I hope so too. And I'm once again grateful that you are on the forefront here, fighting for this right for all of our patients out there. So, Kathryn, thank you so much for taking time to educate me and all of our listeners today.
Thanks for having me. Really enjoyed it. Thanks so much.
Yes, you're very welcome. And good luck in court.
All right.
Hope it goes well.
I'll come back and talk about it when we've won.
Yes.
All
yes.
right, thank you.
That's great. I hope you enjoyed my interview with Kathryn Tucker. I was really impressed to learn about her work. And to be honest, I never really thought about the fact that there were law firms and attorneys who were devoting themselves to making change in terms of the end-of-life situation for our patients, until I talked to Kathryn and found out about her work not only currently with the Psychedelic Practice Group, but also the work she's done as the Director of Advocacy and Legal Affairs for Compassion and Choices, and that she has worked on a number of initiatives for medical aid in dying. So I was impressed, and I feel I have a much greater appreciation now for all the steps that have to occur and all the things that have to fall into place for laws to be changed around our country. So I have a newfound appreciation for everyone working out there to help make these changes happen. So if you enjoy the content of this podcast, there are a few things you can do to help support it. First of all, tell other people about it. You can share episodes with people you know, or let them know about the podcast in case they'd like to subscribe. You can also subscribe to the podcast yourself on any platform that hosts podcasts. And once you're subscribed, then leave a review and a rating, because that helps the podcast be shown to more people. I'm trying to grow the audience of people who learn about and care about end-of-life issues. And then finally, you can also help support the podcast by making a small monthly contribution on my page at Patreon, patreon.com/EOLU. Once you sign up there, you will get access to some bonuses, and you'll be part of the team that's keeping this podcast on the air. So until we're together next week, remember, we're here for love. So face your fear, be ready for whatever comes next, and love each and every moment of your precious life. Bye-bye.